Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
May it please the Court, my name is Hannah Tuber, and I, along with my co-counsel, Paulina Lopez, represent the petitioner in this matter, Professor Wilcox. May you please reserve 2 minutes for rebuttal at this time.
You keep track of your own time, but I have someone's doing it for you.
Your Honor, I believe someone's doing it for me. I will be addressing judicial review of the Assistant Secretary of State's actions under the Administrative Procedure Act, the APA. My co-counsel will be addressing why 18 U.S.C. Section 545's language contrary to law does not apply to regulations promulgated under the Cultural Property Implementation Act, the CPIA. Your Honors, APA review is essential to protect the private rights of U.S. citizens against otherwise vast and unchecked administrative power. In fact, in this case, Professor Wilcox now faces the next 20 years of her life in prison due to the final agency actions of the Assistant Secretary. As such, this Court should reverse the 12th Circuit for 2 reasons. First, the Assistant Secretary is not exercising presidential authority. And secondly, Professor Wilcox is entitled to meaningful—
Well, whose authority is he exercising?
Your Honor, the Assistant Secretary is exercising agency power.
Which agency?
The Secretary of State. She's the Assistant Secretary of State for Education and Cultural Affairs.
But don't they all work for the President?
Yes, Your Honor, they do. The lower court, however, misapplied Franklin v. Massachusetts. That was meant to be only a narrow exception to the general presumption of judicial review. There, first, the plaintiffs challenged the Secretary of Commerce's report to the President. But this Court found that that was not sufficiently final action. In fact, the final agency action was that of the President himself when he gave the report to Congress. The Court focused its reasoning on the fact that the legislators would not have passed the reapportionment statute. In fact, they said that they would not pass it.
But what could be more in the nature of presidential power than the presidential power to enter into treaties, agreements with other countries? Isn't this the heart of presidential power? And it has to be shared with other lower government officials?
Yes, Your Honor. However, there is a distinction between when the President delegates away mere administrative tasks and when he delegates away his actual discretionary authority.
Or you're not questioning the MOU itself?
Your Honor, we're questioning, we're wanting this Court to apply the arbitrary and capricious standard to the inclusion of the French ecclesiastical manuscripts on the import restrictions.
I'm sorry,
I'm sorry, Your Honor.
a little closer to your microphone.
Oh, yes, no problem. We are challenging the inclusion of the French manuscripts in the MOU made by the Assistant Secretary.
But you're really challenging the conviction, aren't you? I mean, if you win on that point, you don't have to worry about this other point, do you?
No, Your Honor. This is still a concern because if all that needs to happen to shield an agency official from administrative review is a presidential delegation, even of his discretionary authority, that would prevent the very purpose of the Administrative Procedure Act, which was to rein in overzealous agency officials. So here, the Court focused on in Franklin v. Massachusetts the fact that the final action had to be in the hands of the President. And in Bennett v. Speer, this Court explained that final agency action is the point from which legal consequences flow. Specifically, the Secretary of Commerce's report could not be considered sufficiently final because there was not a report made in the Federal Register.
Well, how do you differentiate between the agency action and the presidential action?
Your Honor, the The line is drawn when the president delegates away his actual discretion. This court said in Runkle versus the United
He
States.
can't delegate it completely away, can he?
In this case, he has. On page 11 of the record, he no longer has any discretionary authority under the CPIA when it comes to import restrictions.
He has no review authority over what his assistant secretary does?
While he is the president, he certainly, Your Honor, could review anything. We have no reason to believe that he
Well,
is.
that's a debatable subject, whether the president can do anything. It's still up in the air.
Yes, Your Honor.
But if the president were to get on the phone and call the assistant secretary and say, I don't like the way you listed that thing as an artifact, get it off there, that would happen, wouldn't it?
Yes, Your Honor. However,
So why isn't that the president's authority?
Your Honor, because as Bennett versus Spear mandates, final agency action is the point from which there are legally appreciable consequences. So here, the legally appreciable consequences happen when the report is given to Congress and the import restrictions lists are published in the Federal Register. And that point is happening with the discretion of the Assistant Secretary. And she, in fact, does have wide discretion. She is able to disregard the advice of the committee, or the Cultural Property Advisory Committee. She has the choice to disregard what they recommend to her.
Under the statutory scheme, the president could withdraw his delegation of this authority at any time, isn't that right?
Yes, Your Honor. However, that does not bear on the analysis of this issue. Specifically, even in Franklin versus Massachusetts, this court found that if the president were merely acting in a ceremonial or ministerial capacity, they strongly implied that then the Secretary of Commerce's report could be reviewed. Here, the president is not even acting in a ceremonial or ministerial capacity. Furthermore, the lower court misrelied on Ancient Coin Collectors Guild versus the U.S. Custom and Border Protection. Now, they relied on the district court decision in that case where they found that the Assistant Secretary was shielded from judicial review under the APA because she was exercising presidential authority. However, when that case went up on appeal to the Fourth Circuit did not agree with that line of reasoning and instead conducted an APA review on the merits.
Oh, didn't the Fourth Circuit simply say that if we were to conduct a review, then even if we were, it didn't expressly disagree with the district court, did it?
Yes, Your Honor, it did. It did posit what an arbitrary, capricious review would look like and what they would consider. And though they didn't come out on the side of the petitioner in that case, nevertheless, it shows that this is dealing with a legal standard and with statutory construction, which this court is more than capable of dealing with. In fact, in Japan Whaling Association versus the American Cetacean Society, this court stated that even though something may touch on foreign affairs, that does not mean that the court can't enter that area, particularly when it comes to a legal standard such as the APA standard and statutory construction, which is what Petitioner would be asking this court to do. Furthermore, Ancient Coin Collectors Guild, the district court, relied on 3 other cases that are all distinguishable from the case at bar. They relied on Tulare County versus Bush. Now that case, once again, the final agency action, the action from which legal consequences flowed, was when the president determined that a certain area of federal land was a national monument. They found in that case that the Forest Service could not be reviewed because their actions weren't final and that they were merely carrying out the will of the president. So again there, we see that the president himself, under the Antiquities Act, is the one making the decision from which
Didn't the assistant secretary get her authority from an executive order of the president?
Yes, Your Honor, she did.
Well, you could change it any time, you can withdraw it, he still retains absolute control of it.
Yes, Your Honor. However, he does not consider and he does not make a discretionary judgment about the actual import restrictions, which have
How
been...
do you know that?
We have no reason to believe in this case that anyone other than the Assistant Secretary has acted in using her discretion to determine import restrictions. And on page 11 of the record, it specifically states that he no longer has authority over import restrictions. The other 2 distinguishable cases dealt with a different executive order number 13,337. This is Siston Wapton Oyate versus the U.S. Department of State and NRDC versus the U.S. Department of State. Now, that executive order differed from our executive order in 2 crucial ways. First, that dealt only with the president's unique constitutional position, and it had nothing to do with statutory authority.
Certainly, we're not bound to follow Asian coin collectors, but it is the only case that has really looked at this question, isn't it?
Yes, Your Honor, and it's important to focus on the fact that when it did go up on appeal, the Fourth Circuit conducted, as you expressed earlier, a limited review on the merits of an APA claim, but that's all that Petitioner is asking this court to do. Now, if this court's concerned about its future precedent, there is a limiting principle that exists in this case, and that's the fact that the government has not chosen to bring a civil forfeiture action as authorized by Section 2609 of the CPIA, but rather it has brought a criminal prosecution.
So there would be administrative review in a criminal case, but not in a civil case? Is that what you're suggesting?
No, Your Honor. She would get her day in court had they brought a forfeiture action. She could have defended her position, but here they brought a criminal action. And as this court stated in the United States versus Mendoza-Lopez, when an administrative determination is essential in playing a role in a criminal sanction, some type of meaningful judicial review must be provided for the criminal
So
defendant.
you are saying we have administrative review in a criminal case, but not in a civil case. There can be forfeiture without any review of whether the list was arbitrary and capricious, but we would make that review in a criminal case only. Is that what you're saying the rule is?
No, Your Honor. In a forfeiture proceeding, she would still be able to bring this APA challenge as an affirmative defense as mandated by the Substantive Due Process Clause.
But can't you bring that in the criminal case also?
Yes, Your Honor, and that's what we contend here is that because 18 U.S.C. Section 545 requires that an underlying statute be violated, and on page 8 of the record we know the only law, quote unquote, that she's accused of violating.
Well, it doesn't really say a statute has to be violated, does it? It just says contrary to law.
Yes, Your Honor, it says contrary to law. So some underlying law has to be violated. Page 8 of the record expresses that the only domestic law she's accused of violating is the ancillary regulation promulgated under the CPIA. So if that import list was found to be decided in an arbitrary, capricious manner, her criminal sanctions could not stand. And
If we were to say that this really is the president exercising his power in foreign affairs, he seems to be doing it because he's dealing with other countries, doesn't that resolve the issue against you?
Yes, Your Honor. However, this court's precedent in Japan whaling is analogous to here, where they found that while, yes, this does touch on foreign affairs, when it comes to applying a legal standard, such as the arbitrary and capricious standard, and construing a statute, the court is more than capable of doing both of those things. And we see, looking to the Fourth Circuit in Ancient Coin Collectors Guild, that the court is capable of construing those legal issues without having to...
Capable or not, the president's ability to operate in foreign affairs is a unique opportunity, which usually is not subject to judicial review.
Yes, Your Honor. However, here, it is not the president himself acting, and it is an important distinction. As stated in Runkle, when the president's judgment is required, he cannot delegate that away. And while, yes, he can delegate that away, there will be administrative review. Otherwise, judicial review under the Administrative Procedure Act. Otherwise, we have unelected officials, such as the Assistant Secretary, that don't have the checks on their powers, such as term limits, being able to make discretionary decisions without any check on their power.
Will lead to somebody being charged and convicted of a crime.
Yes, and here, exactly, Your Honor, it has been, there has been a criminal sanction brought against Professor Wilcox. In the United States versus Backlund, the Ninth Circuit applied that very principle and found that as long as an APA review is brought in a timely fashion in the context of a criminal prosecution as an affirmative defense, that the criminal defendant is entitled to that review. And for both of these reasons, because the Assistant Secretary is not exercising presidential authority, and because this is in the context of an affirmative defense and a criminal action, we ask that this court reverse the 12th Circuit. Thank you.
Thank you very much. Ms. Lopez.
Please the court. My name is Carolina Lopez and I represent Petitioner, Angela Wilcox. Your Honor, Congress has a responsibility to to put citizens on notice of which of their actions constitute crimes. Congress completely failed to put Professor Wilcox on notice that importing manuscripts contrary to a regulation of
Well, she was certainly on notice, wasn't she? She knew all about it, was doing a little test case.
Your Honor, she was aware that there was a regulation. However, she understood, as the record reflects in page 8, that the regulation only came with civil forfeiture sanctions. There was no way that she could have known that violating this regulation would give rise to criminal penalties.
But aren't the regulations part of the law when they become regulations?
No, Your Honor.
And the statute says contrary to law.
Yes, Your Honor. However, the term contrary to law is ambiguous. The word law can be defined as a statute, or it can be defined like as broad as a group of regulations and laws.
So maybe that was Congress's intent, to have a broad sweeping interpretation.
No, Your Honor. Congress's intent can be reflected on the fact that Section 545 was created after the Tariff Act of 1866. The Tariff Act of 1866 had the exact same language that the Section 545 has. It established that whoever knowingly or willfully imported merchandise into the United States contrary to law would be subject to criminal sanctions. That language was reviewed by one court. The Eighth Circuit in Estes versus the United States found that following the precedent of this court in Eaton and in United States versus Remark, only regulations which were made criminally punishable by another statute could be encompassed within the term of contrary to law in order to give criminal sanctions to a defendant. Congress was aware of that interpretation and reenacted the Tariff Act of 1866 in 1820 and 1930. Congress did not change the language, as this court held in Lorillard versus Pons. When Congress reenacts a statute without a change, it is assumed to be aware of the judicial interpretations and to adopt those judicial interpretations. And for that reason, it can be implied that Congress knew of that interpretation and did not want to include regulations which were not made criminally punishable.
What should have been put in the regulation to put someone on notice that there were other penalties?
Your Honor, what should have been done is exactly what the
I'm
Congress...
sorry, you have to speak into the microphone a little
sorry.
closer. It's too
Why
far.
you have us 301 up here, I can't hear very Unfortunately, we have a keen-eared lady.
Your Honor, to answer your question, what Congress could have done is what they did when they enacted another section, which is Section 554. In that case, Congress included the word "or regulation." That section actually was enacted in 2006 with the USA Patent Reauthorization Act. In that act, Congress amended Section 545, but only to increase the penalties. However, they enacted Section 554, and they took basically the same language section.
Well, could there be something placed in the regulation that would solve that problem?
No, Your Honor, not in the regulation, because it is Congress, the institution that can make criminal punishments. However, it could have been included on the CPIA if Congress intended for its regulations to be criminally punishable. And then, in that situation, that regulation would...
Now, I thought your colleague argued that Congress had nothing to do with the regulations.
No, Your Honor, that is correct. Congress has to do with the CPIA. It was Congress that enacted the CPIA that allowed for the promulgation of the regulations. In that statute, Congress could have established that any violation to the law or its regulations could give rise to criminal sanctions. And in that case, in accordance with this court's holding in United States versus Eaton, there would be no question that the regulation formed part of Section 550.
So are you arguing that no violation of regulation can be a violation of this criminal statute? Is that your argument?
No, Your Honor. This court in United States versus Remark found that regulations can be encompassed within the term contrary to law. However, for those regulations to be encompassed, they have to be made criminally punishable by another statute. For example, in that case, defendants violated a regulation promulgated pursuant to the Forest Reserve Act. However, that act explicitly established that any violation to its laws or regulations would be made criminally punishable. In that case, Congress acted, and they made their intent clear to make the violation of those regulations criminally punishable. However, in this case, there is no statute that provides for criminal punishment for violations of regulations. And therefore, this court should apply those same tests that were applied.
Well, suppose the regulation had a tagline on it that forfeiture, fine, and/or criminal prosecution. Would that solve the problem?
Yes, Your Honor, certainly. That would solve the
And
problem.
that would be in the regulation, not in the statute.
Oh, I'm sorry, Your Honor, then I misunderstood. It has to be on the statute, because it has to be Congress. Congress is the institution that can provide for criminal punishments. And it is dangerous to hold that it is not Congress, or that it is agencies that can do that.
Aren't you asking us to just write all regulations out of the term law? And leave us with what? Lawless regulations? Where are you
No, Your Honor. And this is only for purposes of criminal sanctions, as this court held in Chrysler versus Brown.
What are you asking us to say about this?
What I'm asking you is to follow the precedent of Eaton and Grimard and hold that only regulations which have been made explicitly criminally punishable by a statute can be encompassed within the term contrary to law. And it is simple for Congress to resolve this problem. If Congress wants regulations to be criminally punishable, there is nothing stopping Congress to do it.
They do it a lot.
I'm sorry, Your Honor.
They do it a lot. Don't have to, nothing stopping it, they keep doing it every day, but go ahead.
Yes, Your Honor. And actually, yes, they did it when they enacted Section 554, in which they included that if somebody acted contrary to law or regulations, that would be criminally punishable.
What you're suggesting is they didn't do it here. Congress did not act appropriately, sufficient to give the Secretary the authority she has seized. Is that what you're saying?
No, Your Honor. Congress acted appropriately, and the actual thing, the contention here is that...
So the end result of what happened in this case is predicated on an act of Congress properly interpreted by the people involved?
No, Your Honor. The problem here is
I
that...
didn't think it's meant that. Fair enough for me.
I'm sorry, the problem here, and we contend, is that the lower court erred in the interpretation that it gave to the term contrary to law. Congress did not act inappropriately. When they enacted the CPIA, they could have included criminal sanctions for the violations of regulations. However, Congress did not wish to do so. Moreover, when Congress reenacted or amended in 2006, Section 545, they could have included the word or regulations as they did in Section 554. However, Congress did not intend for regulations, which were not made explicitly criminally punishable by another statute, to be encompassed within the term contrary to law. And that is what this court should hold today, that only those regulations can be encompassed within the term contrary to law. The lower court erred in applying this court's holding in Chrysler versus Brown.
They could also have written the 545 talking about contrary to the statute. They could have done that if that was their intent.
Yes, Your Honor.
Instead, they used the broad term law.
Yes, Your Honor. Certainly they could have done so. However, Section 554 is instructed in that way, in that when Congress uses a word in a statute in a certain way, it is implied that they use the same word with the same meaning. Therefore, it is instructed to know that Congress intended law not to include regulations, and that is shown with the fact that when they want to include regulations, and in a lot of statutes that's what Congress do, is include the word regulation. Moreover, as the Ninth Circuit held in the United States versus Gray, when Congress carefully includes a word in a criminal statute and excludes it in another one, it should not be implied where it is excluded. And that is what this court would do if they determine that that law encompasses regulations.
Well, counsel, doesn't everybody really know that the regulations that are out there are the same as the law?
No, Your Honor.
IRS has regulations out there, you just say, oh, I don't have to worry about those.
No, Your Honor.
Clean Air Act has got stuff in it.
No, Your Honor. The distinction is that it is not that the regulations do not have the force and effect of law. We do not contend that they don't. However, the fact that a regulation has the force and effect of law as to compel citizens to act in a certain way does not mean that that regulation is a law for purposes of establishing criminal sanctions.
Do you question whether these regulations comport with Chrysler versus Brown, meet the criteria of Chrysler versus Brown?
No, Your Honor, we do not contend. They do meet the criteria. However,
You say they do?
They do. So they have the force of law, right? Isn't that what we've said?
Yes, Your Honor, they do have the force and effect of law. And actually, if a forfeiture action had been brought, then, because they do have that, well, or an analysis under requirement would have to be undergo. And if this were found that they do have the force and effect of law, then the forfeiture action could go ahead. However, as this court held in Eaton, in United States versus Eaton, the fact that the regulation...
United States versus what, I'm sorry?
Eaton.
Okay.
The fact that a regulation has the force and effect of law does not mean that it is a law for purposes of criminal prosecutions. Your Honor, it is dangerous to hold that when Congress establishes law, it means to imply all regulations, because it is impossible for Congress to know about all the regulations that exist. However,
But the law was aimed at stopping smuggling. Isn't that exactly what she did intentionally, knowingly?
no, Your Honor, she intentionally and knowingly violated a regulation. However, she did not violate a law, which is required when it is an element of the crime that she has been charged of. It is the place for Congress to impose the criminal sanctions. In this case, Professor Wilcox faces perhaps the next 20 years of her life in prison. And that is just because of an interpretation that, if it is not clear, that does not include regulations, at the very least is grievously ambiguous, and for that reason the rule of lenity must be applied.
This statute has no meaning without the regulations. All the regulations are what define and give this statute a meaning, right? How could you violate the statute without violating the regulations? What would be the statutory violation?
Your Honor, you are correct. The statute requires, the CPIA requires the regulations. And for that reason, because Professor Wilcox allegedly or violated their regulation, then she would be subject to civil forfeiture of the manuscripts. However, and again, we have to look at the term contrary to law of Section 545 to determine whether Professor Wilcox could be convicted under that or not. This court in United States versus Bauer held that when a criminal statute is grievously ambiguous, the rule of lenity must be applied.
What's ambiguous about according to law?
Yeah, it is ambiguous when it is applied to regulations, which have not been made criminally punishable by any other statute. If it is just applied to statutes, then it would not be ambiguous, and it is clear. However, it is confusing that the Congress chose to use the word law and not regulation as they did in another section, if they intended to include those regulations. Actually, this term is so ambiguous that the three courts that have dealt with this matter have come with a different outcome. It is not even clear for the judges that are prepared to deal with statutory interpretations. The Fourth Circuit found that it could encompass regulations. The Ninth Circuit found in United States versus Oliver Sully that did not encompass regulations, but did not make criminally punishable by another statute. And the 11th Circuit in United States versus Izurieta found that because it was not clear the intention of Congress to include those regulations, that defendants could not be convicted pursuant to the rule of lenity. Your Honors, Professor Wilcox had no fair notice that she could have been subject to criminal sanctions, and for that reason, this court should overturn Professor Wilcox's conviction. Thank you.
Thank you. Door? I think you're at bat. You may proceed.
Mr. Chief Justice, and may it please the court.
Let's get close to the mic a little bit, or move the mic over closer to you. That way. There you go.
Mr. Chief Justice, and may it please the court. The 12th Circuit should be affirmed on both issues. My co-counsel, Roy Ross, will explain why Petitioner's violation of the CPIA also constitutes a violation of Section 545 and was contrary to law. I will address the reviewability of the Assistant Secretary's actions. The Assistant Secretary's actions are not reviewable for three reasons. First, Congress delegated authority to the President, not an agency, placing that action within the President's sphere of authority.
The President handed it back.
Your Honor, the action stays within the President's sphere of authority when we look at because Congress knew that the President could delegate that authority away, and we see that by looking at 3 U.S.C. 301. The the Subdelegation Act. It allows the President to delegate authority to any cabinet official or principal officer at any time. It also gives the President the ability to revoke that authority and to either himself or move that authority to any other agency.
But there's nothing in there about him reviewing the Assistant Secretary's actions.
So that if the Assistant Secretary just went totally wild, and the President really didn't care, there's just nothing that can be done about it? Isn't that sort of a far-fetched approach?
So, Your Honor, I believe your question is addressing the due process question, whether or not there's a due process remedy for review. Is that correct?
I'm asking the question.
So if
What do you do if there's no review, and the Assistant Secretary, who's so far down the list of responsible people that we don't even know who it is?
Not an elected official, there's no way to remedy.
So,
You'd make it a capital offense, and there's nothing that anybody can do about it. Is that what you're telling us?
So my response is twofold. First is that we're not asking for all reviews to be eliminated, just APA, this falls outside the scope of APA review, but constitutional review is still available. So all forms of review that is available against the President, which means that if the Assistant Secretary acts in an unconstitutional manner, which, if it's
The court below said to the defendant, to the professor, you don't have any review here.
So that is correct, not under the APA, but if the petitioner, in this case, had raised a constitutional question, or the court in ancient coin collectors allowed review of non-statutory ultra vires action, then that would be allowable. But this is not the first time that the United States has prosecuted someone under an action where it is unreviewable whether or not that action was correct. If we look at actions such as the Arms Export Control Act or the Commodity Control List, both of those allow agencies to list certain items, and then if someone violates that particular action, they cannot challenge whether or not the listing.
That's right in the statute. That it can't be challenged.
No, Your Honor, that was because the court, a certain court in the 9th Circuit and the 11th Circuit held that those listings were political questions because they involved national security issues. And here, we don't have national security issues, we have foreign affairs issues. But the due process protection that is provided here is that the petitioner needs to have notice that these particular regulations are on the books. And if you look at Section 2610 of the CPIA, which provides the civil forfeiture remedy, the only thing the government has to establish is that the regulation was promulgated pursuant to 2604, which is the regulations that are promulgated by the Customs and Border Protection Agency, not the memorandum of understanding that was negotiated beforehand. What that means is, when the government went to trial in this particular case, it had to show that this regulation was actually on the books, and that was published.
Was what? I'm sorry.
I'm sorry?
I didn't understand the word that you just said.
Let me backtrack. So when the government, in order to meet the requirements of due process, what it has to show is that this regulation was publicly promulgated. So it was in the code.
So the presumption of knowledge of the law now applies to the issues that we're talking about. You're presumed not only to know the law, but also know the regulations connected thereto.
So yes, Your Honor, that
It's a consistent position.
Wouldn't you think that somebody who read this regulation would see if I make a mistake and bring this stuff in, they're going to take it away from me and fine me? And that's what they know. Isn't that a regulation that it looks complete on its face? And then we slip in this statute for a little criminal penalty on top of it.
So just to be clear, Your Honor, you're saying, are you asking whether it is appropriate to apply Section 545 in this case, or are you...
I'm saying that the regulations appear on their face to be complete. They prohibit certain things and they punish certain things. And now we're going to add criminal penalties that you don't have a clue that they're being imposed from the regulations.
So first response, Your Honor, is just that the penalty is included in the CPIA, not necessarily the regulation that's in actually the Federal Register. So looking to the CPIA, there is the civil seizure and forfeiture penalty there. My co-counsel co-counsel, Mr. Bratz, will be explaining why Section 545 is also applicable in this.
Well, no, I'm asking you, if when you have everything in the regulation, doesn't that mandate against criminal penalties down the road in addition?
So, to be clear, if you're saying that the enforcement provision or a penalty provision would be in the regulation, then that would preclude other types of penalties? Is that your question?
It would lull somebody into a false sense of security.
So in this particular case, there is no, the enforcement is not within the regulation. The regulation simply,
Enforcement is what?
the enforcement provisions are not within the regulation. The regulation is simply a list.
Sort of following up on that, let me just ask you if you agree with co-counsel's suggestion that at least there should be review when this regulation is used to support a criminal prosecution, whether there should be some administrative review as to whether the list put together is arbitrary and capricious.
So no, Your Honor, there's no due process right for APA review, and the case that the petitioner cited was United States v. Backlund, and United States v. Backlund, the only reason they allowed for review of that particular proceeding, which was done by the Forest Service, was because APA review was available outside of the criminal prosecution context. And actually, the issue in that case was whether or not they could bring it in the civil context and the criminal context. So the central question truly is APA review available?
There can't be two separate rules, one for when it's a criminal prosecution and one for when it's a civil action. You're saying it's either available or it's not available.
That is correct.
In this case, it's not available.
That is correct, Your Honor. And the other distinction is that in Backlund, there was an administrative adjudication that directly implicated individual rights. And in that case, that would be different than simply promulgating a regulation.
What would happen here if instead of doing the criminal statute, they did seize and forfeit the goods? Would she be without any administrative review of that action?
So looking to 2610, which provides what the government has to show in that particular case, all the government has to show.
Can you just direct yourself to my question? Would there be any administrative review if the goods had been seized?
Oh, I'm sorry. So you're asking if there'd be any internal review outside of the judicial proceeding, is that correct?
Any administrative review?
So no, Your Honor, there's no administrative
So they can just seize the stuff and that's the end of it?
Your Honor, they have to bring the forfeiture action in a court. So that the forfeiture action is enforced through an Article 3 court.
So the person agreed to have to bring their own action to recover the goods that have been taken under this section.
Your Honor, I believe the government will need to provide bring the forfeiture action. At that time, then the petitioner could raise the defense as authorized.
The government doesn't have to bring the forfeiture action. The rule says you can just seize it. Would it be up to the professor to have to take some kind of action?
Your Honor, it seems as though the government would need to bring the forfeiture action in order to actually complete.
Well, it wouldn't be unusual. They seize cars and houses and guns and things. The person having it seized has to file an action. Usually under Rule 41.
Correct. So, Your Honor, if that indeed happened, that if she did file a separate action, then we would, the similar type of review would end up happening. Is this done particular to the regulation that was promulgated by the Customs and Border Protection? Was that on the books? Was there notice? And if so...
So her action, whatever it might be, is limited only to whether this thing was listed on paper. She still couldn't challenge the Assistant Secretary's designation of this material. Is that what you're saying?
Yes, Your Honor. And the reason is...
What kind of remedy is that?
I agree that it does not seem as though as strict a review as some people might like, but what we're dealing with...
It doesn't seem there's any review, whether you like it or not.
Sure, in this case, Your Honor, that's correct. There would be no additional review available, but that is because of the nature of this particular action. There are other types of actions where because we have foreign affairs issues at stake here, where the court has long granted the executive branch, particularly the president, broad discretion in implementing agreements that are negotiated with other countries, which is exactly the case we have here. This is an ex-ante executive agreement that is pre-authorized by Congress. This over 200 of these types of agreements are promulgated every year. They are the primary instrument by which the president conducts foreign policy. And if the court begins to conduct abuse of discretion review.
Well, nobody is suggesting that the president can't enter into an MOU with somebody. We're looking at the issue of whether the way it's subsequently enforced is fair and reasonable. And how can we do that if we have absolutely no powers to review anything?
Your Honor, let me just address the issue of the enforcement. What Petitioner is challenging is whether the listing of the material, of the ecclesiastical manuscripts was reasonable. So was Meanden's request and the subsequent MOU, it included ecclesiastical manuscripts. What the Petitioner is challenging is, she's saying that listing was not reasonable under the CPIA.
So she legally bought it.
Yes, Your Honor.
And she declared it.
Yes, Your Honor.
And so she wasn't hiding or smuggling anything.
Yes, Your Honor.
And isn't the question whether it's reasonable or arbitrary and capricious or a regulation to come along and say that a person can't legally acquire something, tell everybody about it, bring it into the country, and then get hammered? Just because an assistant secretary of state chose the wording without any ifs, ands, and buts about it.
Your Honor, I believe that you're looking at the Section 545 question and whether or not it's reasonable.
Well, we'll get to that
Sure.
when the colleague gets up.
What the issue is in this case is whether or not the actual listing was reasonable, not the enforcement. So the enforcement is...
Well, you talk about the listing. The listing is just all-encompassing.
So the listing in the regulation in this case was specifically ecclesiastical manuscripts from the colonial period. And there's
no way to test whether or not this is from the colonial period. There's no way to test whether in fact it's ecclesiastical. We can't have any input whatsoever on that under your position.
Judges get frightened when they don't have jurisdiction to review everybody else's actions.
So just to be clear on the question is whether or not that original regulation was even correct.
But there's more to it than just the listing, because they took the property. She bought it, she possessed it, and now it's gone. And you're leaving her without any kind of way to challenge that.
Your Honor, she does have avenues to challenge, just not the type of avenue that she's seeking.
The only challenge you told me was that it wasn't properly listed.
Yes, Your Honor, and that is the only challenged avenue that Congress has specifically authorized. Because at the end of the day, the APA is a statutory creation, the CPIA is a statutory creation that authorizes, and we're dealing with, has Congress authorized review under the APA in this particular case. If you look at the nature of the action and where the delegation was placed, foreign affairs was placed in the hands of the president, those two factors weigh against judicial review in this case.
Wasn't Franklin meant to be a very narrow decision that you're now trying to drive a truck through?
Your Honor, Congress controls how wide that exception is, because Congress was the one who delegated authority to the president, and if Congress didn't want judicial review to apply in this case, it could have said so. But Congress controls if the action goes into the president's sphere of authority or goes into the agency's sphere of authority. That has multiple impacts on a variety, because it determines, I'm sorry, I don't see my time. It has multiple impacts, and it gives the president more control than he would have otherwise had if the Congress had delegated to the agency. I'll use my time.
Thank you. Next down, Roy Bryce.
May it please the court, good afternoon. My name is Roy Bratz, and I'm also appearing today on behalf of the respondent in this case, the United States. The 12th Circuit Court of Appeals decision was correct on multiple levels. It correctly interpreted the contrary to law provision of Section 545 appropriately to include...
Where do you find words in 545 that lead to the conclusion that it was intended to include
text of Section 545 is a criminal statute and explicitly states that whomever shall bring into the country or import into the country merchandise contrary to law shall be subject to fine or imprisonment for up to 20 years or both.
Yeah, but the regulation you're relying on, you're relying on 2606, right?
Yes, Your Honor.
And that's, the only penalty there is subject to seizure and forfeiture.
That is
There
correct.
is a penalty there, but it has nothing to do with criminal prosecution.
That is correct. The penalty provision provided for in the Act itself is an exclusively civil administrative.
Presumably Congress knew how to say law or regulation.
That is correct.
In other instances.
And
Yes, Your
didn't
Honor.
both the Ninth Circuit and the 11th Circuit make that very distinction?
Well, I think nor does the statute preclude application of a criminal sanction, especially when the statute that was violated speaks directly to the purpose that Section 545 was enacted to deter. The fact remains that Congress enacted the CPIA with an embedded civil penalty provision, but under this court's rationale in United States versus Borden, when two independent statutes have provisions that work together,
This wasn't exactly a smuggling case. So she lands and she says, by the way, I have these things. I mean, she wasn't hiding them, she wasn't concealing them. She was making a point of saying that she had them. Where's the smuggling?
That is correct, Your Honor. The smuggling statute is a misnomer of sorts. The operative paragraph of Section 545 that's implicated in this case is paragraph 2. That paragraph states merely that one who knowingly or willingly brings into the country merchandise contrary to law. It doesn't indicate that there's a limitation only to those parties who intend to smuggle them.
Congress got it wrong when it used the word smuggling, and Congress got it wrong when it said contrary to law and not regulation. What more do you want us to do?
No, Congress did not get that wrong. Under this court's longstanding presumption, the definition of law is a broad definition and includes administrative regulations in addition to statutory law, absent congressional intent to the contrary.
So your partner just argued that this regulation should be unreviewable under the APA. You want it to be unreviewable and you want it to be a basis for criminal action. Is that what you're saying?
Yes, Your Honor. The petitioner in this case had other means of reviewing. She could have filed a civil challenge to the enforcement of the statute. She could have raised a constitutional challenge. She could have also raised...
And without breaking the law, without breaking the regulations, just file a suit ahead of time.
I'm sorry, Your Honor.
You mean filing the suit ahead of time to challenge the validity of the regulation without breaking the regulation herself?
Had she been unsatisfied with the regulation as written,
I'm suggesting that's what the government wanted her to do, to bring side action without bringing the goods in, bring the action and test it beforehand.
Your Honor, the means available to her or any member of the electorate, if she wasn't happy with a political decision, namely a congressional enactment, she has every opportunity to petition her legislative representatives to change the law.
Yeah, but she can't bring an action unless she has standing to bring an action. That means violating the law.
That is correct, Your Honor.
There's nothing she could have done then.
The petitioner could have done something, Your Honor, respectfully.
Well, what could she have done? Tell us what she could have
Well,
done.
she had every right and opportunity.
She couldn't do a declaratory judgment action.
No, Your Honor.
Yes, my question was answered. Go ahead.
Without standing, she would have been able to petition for a declaratory judgment, but in this case, where in the court below she had every right and opportunity to explain herself in the trial court, which she did, albeit unsuccessfully, she could have also raised a number of other defenses.
How do you respond to the argument that Congress in Section 554 used the phrase law or regulation? So Congress knew how to do that when it wanted to, but it didn't do that when it reenacted the statute in this case. How do you explain that away?
That is correct, Your Honor. A cardinal principle of statutory construction holds that, that denominated as congressional acquiescence. In other words, Congress is presumed to be aware of how courts have interpreted statutes when reenacting or amending statutes. In this case, we have 140 years of precedent establishing judicial interpretation of the term statutory, contrary to law, to include regulations. That's about 140 years, including the predecessing statute, Section 545.
Well, haven't we said specifically, we've never defined, specifically defined, contrary to law?
The contrary to law, the term law is not statutorily defined, but this court has sort of played around with the idea of what may constitute law in Chrysler Corporation versus Brown, where absent congressional intent.
Chrysler was in this court.
I'm sorry?
Was that this court?
Chrysler Corporation versus Brown, United States Supreme Court, yes, Your Honor.
But we didn't say there that all all regulations have the force of law, correct?
That is correct. Not all regulations have the force and effect of law. Where they would not have the force and effect of law is where we have congressional intent to the contrary. Congressional indication that Congress did not intend for those regulations to be law. Nowhere in the text, the history, the structure of the regulation, the CPIA, is there a congressional, an apparent congressional attempt to preclude application of a criminal penalty. I might remind the court.
So Congress has to specifically say no criminal penalty, or there's a criminal penalty? Is that what you're arguing?
Yes, Your Honor. They have made a practice of that in the past, and especially considering the degree of severity of the penalty, if Congress had genuinely intended for the penalty to be merely civil, it's not unreasonable for us to expect them to say that.
Isn't that turning the rule lenity on its head, that if there's any confusion, we have to assume the ambiguity means no criminal?
No, Your Honor. I'm sorry. No, Your Honor. There is no ambiguity in this case based on the contrary to law provisions understanding this court's long-standing jurisprudence, which indicates the definition of law as a broad one to include administrative regulations such that administrative regulations are the full equivalent of statutory law. The increasing prevalence of administrative law, this court, given that increasing prevalence of administrative law, this court recognizes administrative regulations to have the full force and effect of law, absent congressional intent to the contrary. There is no congressional intent to the contrary. There is not one point at all in the text of that statute where one can point to the word civil. Nowhere. There is no explicit or implicit indication on Congress's part to limit application of Section 545. They were aware that Section 545 existed. They were aware that it was an import statute and that it would apply generally to all statutes and regulations promulgated under those statutes that related to import violations. CPIA is clearly an import statute. It clearly proscribes importing items into the United States that are subject to...
554 is clearly an export statute, and it specifically uses the word regulation, as
Yes, Your Honor, it does.
pointed out. So explain that.
Again, the doctrine of congressional acquiescence indicates that when reenacting or amending a statute, that Congress is presumed to be aware of how courts have interpreted the term contrary to law. There's 140 years of precedent.
But we didn't make a flat statement in Chrysler that all regulations are subject to criminal statutes. We just said that.
This court did
It
not
could
say
happen. We just say, well, it does happen.
that is correct, Your Honor, but it did not limit application of the Chrysler traditional understanding test either. It essentially laid down a broad rule without limitations on when regulations can have the force and effect of law. It's substantive, procedurally sound, and promulgated pursuant to legislative.
So under that theory, then, are you asking us to say that every regulation, no matter what it is, wherever it exists, every regulation, the violation of which would be a criminal statute?
No, Your Honor. Where
What are you asking us to say in this case?
I'm sorry.
What are you asking us to say in this case?
Based on the facts of this case, what we ask the court for is upholding the application of Section 545 for a violation of import statute, where Congress has not indicated any indication of it to preclude criminal punishment. The increasing prevalence of market and vestiges of of significant past artifacts of cultural heritage indicates that the problem needs some way to deter conduct such as the petitioners. Without such a provision, if I may respectfully ask the court, what in fact are these regulations regulating if they don't have an enforcement mechanism with teeth sufficient to deter conduct such as the petitioners? It essentially facilitates her ability to continue to try and try again until that one time when she does manage to get through, and there she can sell or whatever the intentions may be for those items. But the Republic of Mandan is now.
You give her a chance to show that the Assistant Secretary made a mistake when he put this thing on the list.
She could certainly lobby her legislators if she was unsatisfied with the. I agree, Your Honor. But
So you asked us to confine our conclusion to this kind of smuggling case and stop right there, or will this apply to other cases where the statutes are similar?
not necessarily. Where Congress has expressed an intent for to preclude criminal punishment.
Right, that's what I'm saying. Are you asking us to say that unless Congress has expressly said no criminal punishment, all regulations are subject to criminal statutes? Is that what you're asking for?
I'm not presuming to request that this court.
I'm trying to find out where you want to take us.
Well, what I would like is that under the circumstances of this case and the egregiousness of the defendant's behavior in importing items that she was fully aware that were subject to import restrictions, that criminal penalties should apply.
So we should limit our finding to egregious cases and not mild cases?
I'm asking this court to reflect on the circumstances specific to this case. It would be presumptuous for me to request a broad rule that encompasses.
You're from the Supreme Court of the United States, it wouldn't be presumptuous.
Are you suggesting that 545 incorporates only regulations that have to do with importing? Is that what you're saying? And those statutes are the ones where the regulations are become criminalized by 545? Is that what you're saying?
Absent congressional intent to the contrary. If I may just note for the court that its decision in the United States versus Borden suggested that where there are two unrelated statutes, both providing for provision, that the court should give effect to both if possible.
Well, doesn't this discussion that we've been having suggest that the rule of lenity ought to be brought to the fore and applied to at least this case until this issue is resolved?
No, Your Honor. The contrary to law provision is not ambiguous merely because it lacks the or regulations.
Well, we have the Al Gazzoli case where the regulation specifically was made subject to criminal prosecution in addition to the other problems. We've got the Israeli case where it's strictly civil and monetary and there's no reference to criminal, that there is no criminal penalties there. So it's at least ambiguous to the Ninth Circuit, which might not be a surprise. And it's also ambiguous to the 11th Circuit.
That's an American decision.
And it seems to me that the rule of lenity doesn't have to just go to a given word. It's got to go to the application of the particular statute to the particular facts.
No, Your Honor. Where the Ninth Circuit got it wrong in Al Gazzoli is that they created a rule for that district, which of course is not binding on this court, perhaps persuasive, but essentially nullifies Section 545 such that it is useless because it can no longer apply in conjunction with any other statute because that statute would have to stipulate that a criminal punishment would apply or that Section 545 applies. Section 545 is still on the books after 140 years. It's signifying that if Congress considered it redundant, that it could repeal it. And over the course of 140 years, it has chosen to keep that statute on the books. Courts and prosecutors have regularly applied Section 545 in circumstances where regulation...
They haven't had a case like this, where the regulation like this is being
Your Honor, a 2012 case out of the Central District of California was a case, Your Honor, it appears as though my time has expired and I finish my point. This case was a case that concerned the application of Section 545 under the CPIA. It was Perez versus the United States. In that case, it ended in a plea deal, so it was never adjudicated on merits, and thus no rule emerged. But what it does indicate is that federal courts, considering the prevalence of the international black market in cultural patrimony, are willing to entertain application of Section 545 under the CPIA. It managed to find its way through the indictment process, the criminal complaint. It was never dismissed, and therefore this court should follow that reasoning and in order to further the objectives of the CPIA, establish criminal penalties as a nation of laws. We owe that to the people of the United States. Thank you, Your Honor.
Thank you. Are each of you taking advantage of the rebuttal? Each of you?
No, just
you.
yes. May it please the court? Petitioner has 1 point on rebuttal. Contrary to Respondent's assertion, it is unreasonable to expect that Congress should include in their statutes when they don't want to bring criminal sanctions. Congress, on the other hand, has to establish when they do want to include criminal sanctions, as they did in Section 545, but only for violations of the law. If Congress intended for violations of regulations to be included, it would have done so distinctly. And that is what this court has required in United States versus Eaton and United States versus Moot. For that reason, we respectfully ask this court to overturn Professor Wilkins's conviction. Thank you.
Thank you. Thank you to all parties involved. We will now retreat to our wizard cave, confer amongst ourselves and arrive at some decision, and we shall return.
All rise.